Today I am going to discuss with you a very vital topic regarding medical negligence. होता क्या है कि अगर पेशेंट के अकॉर्डिंगली रिजल्ट नहीं आया तो द डॉक्टर इज अरेन्ड, imputed or implicated, making false allegations on him under section 304A of Indian Penal Code, that is medical negligence. लेकिन ये गलत है. अगर डॉक्टर ने अपने आप को thoroughly involved किया है and he has worked diligently, then he should not be implicated for an offense which he has not done. What does the Supreme Court say regarding medical negligence? I am going to tell you in that context. Supreme Court कहता है, simply because a patient has not favorably responded to a treatment given by a doctor or a surgery has failed, the doctor cannot be held straightway liable for medical negligence by applying the doctrine of res ipsa loquitur. ये एक लैटिन टर्म है जो कहता है res ipsa loquitur, मतलब कि the situation or the incident speaks for itself, मतलब कि इसको प्रिज्यूम नहीं करना चाहिए कि डॉक्टर की नेग्लिजेंस रही होगी. No sensible professional would intentionally commit an act or omission which would result in harm or injury to the patient, since the professional reputation of the professional would be at stake. A single failure may cost him dear in his lapse. As observed by the Supreme Court in Jacob Matthews' case, a medical practitioner faced with an emergency ordinarily tries his best to redeem the patient out of his suffering. He does not gain anything by acting with negligence or by omitting to do an act. Obviously, therefore, it will be for the complainant to clearly make out a case of negligence before a medical practitioner is charged with or proceeded against criminally. A surgeon with shaky hands under fear of legal action cannot perform a successful operation, and a quivering physician cannot administer the end dose of medicine to his patient. If the hands be trembling with the dangling fear of facing a criminal prosecution in the event of failure for whatever reason, whether attributable to himself or not, neither can a surgeon successfully wield his life-saving scalpel to perform an essential surgery, nor can a physician successfully administer the life-saving dose of a medicine. Discretion being the part of valor, a medical professional would feel better advised to leave a terminal patient to his own fate in case of emergency, whether the chance of success be 10% or so, rather than taking the risk of making a last-ditch effort towards saving the subject and facing a criminal prosecution if his effort fails. Such timidity forced upon a doctor would be a disservice to society. ये कहना चाह रहा है कि अगर डॉक्टर्स के ऊपर ये लीगल ऑब्लिगेशन बना रहा कि नहीं, अगर उन्होंने कोई ऑपरेशन परफॉर्म किया या उन्होंने कोई मेडिसिन एडमिनिस्टर की और उसके चलते पेशेंट को वो रिजल्ट नहीं आया जो होना चाहिए या जो आ सकता था, जबकि डॉक्टर ने अपने आप को थॉरली इन्वॉल्व किया है एंड ही हैज वर्क विद ऑल हिज प्रूडेंस एंड डिलिजेंस, तो इसका ये मतलब नहीं है कि उसको इम्प्लीकेट कर देना चाहिए, वरना वो कोई भी इस तरीके का काम करने में जिसमें जरा सा भी रिस्क इन्वॉल्व होगा वो नहीं करेगा, and that will be fatal to the society at large. When a patient dies or suffers from some mishap, there is a tendency to blame the doctor for this. Things have gone wrong and therefore somebody must be punished for it. This is what a patient thinks or a complainant thinks, but this is not so. However, it is well known that even the best professionals, what to say of average professional, sometimes have failures. A lawyer cannot win every case in his professional career, but surely he cannot be penalized for losing a case provided he appeared in it and made his submissions. एक लास्ट पैरा पढ़ूंगा जो बहुत इंपॉर्टेंट है इस रिगार्ड में, मेडिकल नेग्लिजेंस से के रिगार्ड में, जिससे कि ये होल इश्यू डिफ्यूज हो जाए. ये सुप्रीम कोर्ट ने कहा है कि व्हाट प्रोसेस शुड बी फॉलोड बिफोर मेकिंग अ डॉक्टर क्रिमिनली लायबल और कल्पेबल. A private complaint should not be entertained unless the complainant has produced prima facie evidence before the court in the form of a credible opinion given by another competent doctor to support the charge of rashness or negligence on the part of the accused doctor. The investigating officer should, before proceeding against the doctor accused of a rash or negligent act or omission, obtain an independent and competent medical opinion, preferably from a doctor in government service, qualified in that branch of medical practice, who can normally be expected to give an impartial opinion applying the Bolam test. A very important test है. A doctor accused of negligence should not be arrested in a routine manner simply because a charge has been leveled against him, unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigating officer feels satisfied that the doctor proceeded against would not make himself available to face the prosecution unless arrested. The arrest should be withheld. ये चीजें ध्यान में रखनी चाहिए before making any type of arraignment or allegation on a doctor. Criminal allegation. This is very important. Bullen test apply होना चाहिए. Investigating officer को सीधे जाकर उसे arrest नहीं करना चाहिए. He should go on to take advice of some competent doctor who is well versed with that particular field. I will request to all my friends, don't panic at all. There is a Supreme Court judgment. If somebody goes on to implicate you in medical negligence, you will get relief by this particular judgment of the Supreme Court, which explicitly says that if there is no error or if the doctor has worked with prudence and diligence, he should not be punished. Thank you.